For this short video, we're going to look at interviewing clients using interviewing models and specialized techniques. We're going to focus on one particular model called the funnel technique that you'll see a lot when you talk about how lawyers interview clients. I'm basing this presentation on the knowledge that you've done some exposure to interviewing and client counseling in the context of your property classes, but we're just going to take a little bit more of an in-depth look at it in our class. Right, most interviewing has a three-stage approach. The first stage when you meet with a client is really developing that initial client rapport and doing a preliminary identification of the problem, the reason the client is there to see you. Once you've identified the large problem, you want to elicit a timeline from the client. You want to understand the events that gave rise to this larger conflict and basically get the big picture so that you're not missing any large pieces to the puzzle. And then lastly, you want to spend time developing the facts that you need to develop the theories for your case. We're going to, in class, focus primarily on this third stage just due to timing issues. We really don't have the time to sit there and develop the client relationship or really even get the big picture. So I'm going to start with the assumption we have those things in class. All right, so let's talk about each of these phases. For problem identification, the first thing you want to do is greet your client. And it's important to engage in pleasantries for icebreaking purposes. A client doesn't feel comfortable even when they've sought out your legal advice, opening up to you about all of their issues. They need to understand that you're someone who's going to listen to them, that you're going to be able to provide the kind of representation that they're looking for. And so being able to talk about just basic pleasantries is important. After you've established some baseline for rapport, you want to make sure that you identify the client's problem. You know, what is the real reason they're here? In our lawsuit, Ms. Parson is going to be contacting you because she's had an injury in a rollerblading accident, namely that another person, the defendant that's going to be represented by Professor Gillis's section, has injured her by striking her with a vehicle while she was rollerblading. And so that's drawn her to you. She's got some sort of need for legal relief. And so that's our next issue, which is, well, what does she want from this? Many clients really want money to help compensate them for the loss they have. So if they've had an injury and have had time off work or have had some other issues, they're looking for monetary relief. But don't presume this is always what clients are looking for. Sometimes clients want some sort of remedy that isn't just solved by damages. They might want to have something returned to them. They might want to have an opportunity that they don't currently have. They may even really just want someone else to admit that they were wrong. You know, some outcomes that clients are seeking are not always provided under the law. And so what you need to do is help the client identify what a legal remedy they could get, like, for example, damages through the enforcement of a judgment. And then also identify where litigation might not be the right approach to take in resolving their problem if they're looking for outcomes that are something we can't support under the law. In addition, you want to get the client's ideas about the case and about what the conflict is. You know, really the way that lawyers and clients work when you have a competent client is to have them take the driver's seat in making sure that their needs are being met. And so it's important to solicit their ideas. Also, you want to make sure if they have any other concerns. You may be totally unaware that this person has a strict deadline that they're working on, and not only do they need particular damages, they need them in short order. Or while they might want damages, they might need a certain set number right now or a certain amount, like if bills are coming due, and might be willing to forego their entire desired damage amount if you can recover this quickly. And this helps you in facilitating not only your case, but in settlement negotiations. Additionally, they may have concerns that are totally unrelated to the relief they're seeking or their desired outcome. They might have pressures outside of the litigation that is going to drive the decisions they make. For example, they might have extreme anxiety about going to court. There might be a relationship with the person that they're trying to sue, and they're concerned about injuring that relationship. So it's really important to get a general understanding of what the client's concerns are. Once you've concluded this preliminary problem identification phase, what you want to do is give the client a brief explanation of what you plan to do in conducting the interview, including telling them that you're going to do things like ask questions multiple times just to make sure that you have the correct answer. Just explaining to them the purpose of what you're trying to do and that you may be delving into topics that they might find uncomfortable, just alerts them so that they feel like they have some ownership in the process. All right, so the second step, eliciting a timeline. Your goal here is to give the client to give you a chronological list of the events that are the subject of the problem. And you may quickly realize that a portion of relevant information is out there that the client might not even have been aware is something that you need to know. Is you want to make sure you understand what the picture looks like, the big picture here, not just to focus on maybe the most thing that's pressing on the client's mind at that moment. They may be mostly concerned about a particular event, but when you explore the entirety of all the events between these two individuals, the people that you might be bringing a claim against, you might realize there's other people out there that they have a claim against, or that there's other incidents that give a better context for what occurred that may create a claim or may remove a claim that this client has. So making sure that you understand the big picture is really important, and getting a general timeline of everything that happened that might relate to this is a good way to ensure that you have that. You shouldn't assume that the client is going to be able to give this big picture view for you. They're coming to you because you understand what the law requires in order for them to get the relief they're seeking. They don't know what the law requires, so while they might think some things are irrelevant or some things are highly relevant, they may be completely wrong. So you need to make sure that you ask them large questions and chronological developing questions so that you can help them give you the information you need. So don't expect them to be the driving force here. Okay, so for purposes of our exercise, we're going to assume that you've had at least some general idea of what the problem is, that she's been involved in an accident and she's been injured, but you don't have a whole lot more than that, so you're going to want to, work from these basic premises into our third stage, which is theory development. All right, in theory development, what you do is question the client to bring out the key facts. This is a big bulk of the time you spend in interviewing, and really where we're going to focus in our class. All right, so what are key facts and how do you know? Well, key facts are the facts that are material depending upon the legal rules that apply. So you need to plan your questioning based upon the legal elements that you must prove or disprove. And so that really begs the question, well, what kinds of claims do you think when someone has been struck by a vehicle while rollerblading, they might potentially have? All right, so you want to think about those potential legal claims. And we're focusing on a simple dispute here because I want to make sure that we're in law that you feel relatively comfortable with. So we're going to be looking at torts. You're going to want to look at what kinds of claims a person who's been injured by another motorist while they were rollerblading might be able to bring. Understand what those elements are, and then think about the questions that you would need to solicit answers to from the client to be able to decide whether or not you can actually present a claim on those types of torts. All right, so one technique you can use while doing theory development that is critical is called the funnel technique. And this kind of questioning technique basically moves from broader topics into more narrow ones. So what you want to do before Monday is identify topics and subtopics that need development. And again, your reference point is the law. So think about what tort claims a person who is injured because they were struck by a vehicle while they were rollerblading might bring. Think about what those claims are and what kind of elements you have. So break those elements into topics or subtopics and think about the questions you need to ask to develop an understanding of whether or not you could prove these claims or even plead these claims. All right, so here's a depiction of what the funnel approach looks like. After you've identified those topics, you're going to explore them one by one, and you want to initiate the exploration of each topic with very broad, open-ended questions. What your goal here is to really have the client give you a narrative. You don't want to be the focus here. So it shouldn't be like, here's lawyer asking a rapid fire succession of questions. You really want the client to take center stage. Don't interrupt their narrative. Allow them to give you the information that you need so that you can get the big picture. What you don't want to do is make a prejudgment here and decide you think you understand what happened and go into deep, more specific questions, excluding the possibility that there's parts of the story you don't already know. So since all you know is that she was struck by a car, what you want to do is have very broad questions at the beginning of this interview that really allow Miss Person to tell you what happened. All right, you can assume, however, that there's going to be a chance to follow up on these questions. And many of these questions, because it's just a basic kind of car accident, are ones you can probably anticipate. So after you hear her narrative, you want to start asking open-ended follow-up questions. So you're still not asking specific directed questions where you're supplying basically the topic and the answer. Like, you don't want to ask a question right at this point that is a yes or no question or too specific. What you want to do is get a little bit more narrowing of the information, but still let the client take the driver's seat. You don't want to exclude any opportunity for the client to give you a better understanding. And the moment you start moving into more closed questions, one that are more yes, no, ones that are like about specific details, what happens is the client starts to shut down other potential opportunities to give you information you don't know. So for example, you might think you understand what happened, ask really, really narrow questions about a specific aspect of that, and the client's starting to get the subtle message that this is the important thing. And so they may stop telling you about other topics without even intending to. So they're not holding back, they're just answering your questions. The client generally wants to answer your questions, and so they'll follow your lead. So what you want to do is hold back hold back and let them take the lead, so that you can make sure before you start asking specific questions that you have a full understanding of what's happened. All right, so what are open-ended questions? These are your classic who, what, when, and why. So you can envision a big narrative from this person might be that the logistics of the car accident, and you want to let her just give the whole narrative from top to bottom, what happened. And then you might want to start back and say, well, what happened before this event, or who else was there, and when did you notice X, Y, or Z? So with the who, what, when, and why questions, you're really allowing them to jump into a portion of the narrative that you've already heard and give you more detail. But again, note that none of these questions are, did you do this? Or can you answer, was this the situation, yes or no? You're really asking these large, open-ended questions, who, what, when, and why, to still give the client more freedom to tell you what's happened. After you feel like you've got a good understanding of that, at that time you can use summary to check your understanding of the client's facts. So you can say, so you told me that you first noticed the driver doing blah blah blah. So what you're doing is basically mirroring back what they've told you, but you're just trying to make sure that you've heard it correctly. And then after that, you can ask those close-ended questions to clarify. And by that I mean you can say, well, did he have a red shirt on? That's a close-ended question. So you've listened to the story, you want to make sure you understand it, and then you can ask the narrow yes or no questions, or very, very focused specific questions, but only at that point in time. And so if you look over at our depiction here, that's because you're at the bottom of the funnel, but you've really spent most of the time in the interview up here just trying to gather information. Don't ever shut down the opportunity to gather more information. So be very hesitant to get to any of these more focused questions until the very, very end. Realize that much of the interviewing process is going to be a looping between topics. So you are going to let them start an exploration through their narrative of one of the topics that you've identified you want to talk about. So since you understand what legal claims might arise out of this kind of an accident, you might start off on a topic of about what actually happened that day, so that you can get a better understanding of if you've got the legal elements for those claims. But as you're talking to this client, you may realize that some of the questions they're asking you don't necessarily relate to your initial topic. And so you may loop between topics, going from who, what's, and when's between multiple subtopics. So the best thing to do when you do any looping is do what we call signposting. So you can say, I'd like to talk to you about the morning of the accident. And by doing that kind of a signpost, you direct the client's attention to that particular topic you're going to now talk about, and then you can ask questions in which you can solicit answers about those more other topics that you've looped to. All right, I'm going to show you a clip of a video that's from the American Bar Association.
You can use an interviewing method called the
on funnel techniques. I use this in some of my other classes. This particular video is directed towards interviewing children, but I will tell you that the funnel technique is universal, not just used with clients that lack capacity like kids. In client interviews with children, the funnel technique is you have to be even more cautious with, because when you ask more directed questions of children, they tend to supply incorrect answers. They want to, often please you or often answer a question in the affirmative because they think that's what they should do. Adults don't do that quite as much, so some of the caution here you don't need to be quite as concerned about, but I think this is a great example because you're going to see a lawyer and a client work through some of the broader questions in this funnel technique. Once you've watched this last bit here, then what I would like you to do is look at the handout that I gave you for today and fill out the questions you think you might have that are open-ended questions, the topics you might want to identify so that you can prepare for our interview on Monday.
funnel technique to encourage the child to give their account of what happened and to develop facts important to the case. Asking open-ended questions, letting the kid run with it, and then following up with narrow questions, and I find it to be extremely effective. In the first stage of the funnel technique, the lawyer allows the child to tell the story uninterrupted. In the second stage, the lawyer asks open-ended questions to further develop facts. In the third stage, the lawyer confirms facts through a series of narrow, close-ended questions. Here is an example of the first stage, where the lawyer allows his client to speak uninterrupted.
So, why don't you tell me what happened when Oscar got hit?
There was one particular game we all wanted to play, which was called WrestleMania, and you throw the person in a body slam by throwing them onto the floor. And then, out of nowhere, I
let them tell me the story at least once, if not more times, all the way through without my asking any questions.
It shows the child that you're going to let them speak, that you're not going to cut them off, that you don't discredit their story because they're a child. But it also begins to reveal to you their view, where they're sitting in this whole narrative, in this whole story, their perspective on it, what's important to them.
Stage 2 of the funnel technique is your chance to track back through the story using open-ended questions starting with who, what, where, when, why, and how to clarify the story and continue to develop facts.
Okay. So, let's go over that again slowly so I can understand each part. When did it all start?
It was a month ago. Me and my brother were staying with our foster mom, Deirdre, and we had seen a show on TV called WrestleMania.
Oh, what's WrestleMania?
WrestleMania is when you throw the person in a body slam by throwing them onto the floor.
Tell me more about that. Does it hurt?
No, because we had put pillows down on top of the rug that was in the room, so when you fell down it didn't really hurt that much, and we were all doing it to each other. Oscar was doing it too, so.
Yeah?
Yeah, and then Shorty got mad because he said we had thrown him down too hard, and he picked up a bat, and he had hit Oscar with the bat. And that was it. And the police came.
What did Shorty do with the bat?
He had poked Oscar in the stomach with it.
Poked?
Yeah, poked.
And what happened to Oscar?
Oh, well, Oscar sort of fell down holding his stomach, crying.
Can you show me what Shorty did?
Yeah, he picked up a bat and said he threw me down too hard, and he poked him in the stomach with it.
Well, how soon?
Open-ended question.
Okay, so what you can see from the video, I think, is a really good demonstration of how the narrative gave the lawyer a lot of information about the event that this particular child who's in a delinquency setting and is going to be charged with an assault against this person that she was in foster care with, gives an idea of what happened and really from the client's perspective. But you can see, like many narratives from clients, and this honestly is not so different with adults. It happens more from their perspective, so timing issues and clarification is not often provided by the client, but that's okay. You let them give it to you so that you understand from their perspective basically the full picture. But then I think the lawyer in this video does a great job of asking those follow-up clarification questions. It was really clear to me that the lawyer really understood what really happened, and they did that by saying, so what happened then, and who else was there, and can you describe to me what you mean by this name, and can you demonstrate that for me? And all of those questions were still open-ended. At no point in time did he ask a close-ended question. Now the video from here goes into a different example when it shows close-ended questions, but let me just give you one close-ended question that could have been asked by this lawyer in this context so that you can see the difference. So she's talking about what she's being charged with, which is the assault with the bat on the other child. A close-ended question could be, did he bleed? Did he cry? Those kinds of things are more close-ended because you're asking about a specific detail, and the answer is really yes or no, or with just revelation of one fact. Do you note the difference between saying something like, did he bleed? Did he cry? Was there a bruise? Was someone else there? Those questions are close-ended versus the what happened next, or can you explain what you mean by this? Can you show me these things? Those things are much more open-ended because it gives the client a lot more availability of facts from which they could answer your question. You know your question is close-ended if there's only going to be like a one-sentence answer or if it's a yes or no. All right. So hopefully this was helpful, and I hope you enjoy the exercise on Monday. I'm not going to be collecting anything from you on Monday, but we will use this information as we put together the complaint, which is due on Thursday. Now, one thing you should feel comfortable with is I am going to give you a memo from a paralegal, which is going to be me to you, that actually has the information that you need to file the complaint. So if for some reason the interviews don't go as well as you hoped, don't be concerned. In the end, I will give you the information you need, but it will really just be supplementing what the client says to you on Monday. But I have all confidence that you're going to do a great job with this, and hopefully you'll really enjoy this experience.